Joining me today is Kathleen Flammia, who specializes in elder law and Medicaid planning. Kathleen, it's always good to see you, and I'm somewhat intimidated talking to an elder law attorney, but I realize I really do need help in trying to understand estate planning. So today, will you just give me a basic 101 on estate planning?
I'd be happy to. And even the word estate planning conjures up images of people that have lots and lots of money and they have this elaborate estate plan. But really, Serena, anyone over the age of 18 needs an estate plan. The reason is because once you're over 18, you're an adult, and therefore, if something happens to you, if you become involved in an accident and you're unable to make healthcare decisions for yourself, or if you're unable to handle your finances, that it's important that you have some basic estate planning documents in order.
All right, well, let's just start right there with estate. What do you consider to be one's estate, and what are some basic estate planning documents?
Your estate is basically everything that you have in your name: your house, your car, your personal property, your bank accounts, your life insurance policies, things along that nature. That's what makes up your estate. And your basic estate plan, one that I think everyone over the age of 18 should have, is a will. And that's basically written instructions to the court on how you want your property to pass after you die. A durable power of attorney, and that's a document that's very effective and very powerful. It allows someone else to handle your finances for you. And it's typically effective the moment that you sign it. So say you had a real estate closing and you were going out of town, you could sign a limited power of attorney to allow someone to handle that transaction for you.
I hear people talking about trusts, and so how do trusts fit in with this estate plan?
That's a really good question, and a trust is different from a will. As I said, a will is basically written instructions to the probate court, and it says, court, please admit this will to evidence, and after I pass, here's how I want my stuff to pass. It guarantees probate. A trust, on the other hand, if when properly funded, would hold the title of your assets, and it would allow someone else to act as a successor trustee for you, or even an initial trustee for you, if you didn't want to be in charge of your own trust assets. And it gives more instructions on how things should be handled for you. Say, for instance, you become very sick and you have your money titled properly in the name of a trust. You're in charge of your trust and you can't handle it any longer. Your successor trustee can step in and handle your money and spend it on you as you've stated in your trust agreement. And then after you pass, it avoids probate. It's a private document, whereas a will is a matter of public record filed with the probate court.
Okay.
And you can control your assets even after you pass. You can either leave them outright to beneficiaries or leave them in trust for beneficiaries.
Now, do you have to have a certain amount of money in order to establish a trust? I think a trust for the very wealthy.
No, actually you don't. We generally recommend a trust if you have more than one piece of real estate, especially if it's out-of-state real estate, to avoid an ancillary probate in that state after you pass. But typically, even people who are single want to have a trust to put their money in so that if they become incapacitated, someone else has clearer, more detailed instructions on how to handle their finances. And again, it's a private document and it avoids probate.
Well, I see that we are really just beginning to scratch the surface of estate planning, but you've given me some ideas, Kathleen, and so I think I need to begin work on this. Thank you very much.
Thank you.